READ, Real Estate Agency Disclosure and Election. Form. The Arizona Association of Realtors offers several standard forms, and among them is the READ, Real Estate Agency Disclosure and Election form. This particular form serves as a non-binding, non-exclusive agency disclosure, presenting information in two distinct parts. The first section of the form functions as a disclosure, elucidating three agency types: buyer representation, seller representation, or limited dual representation involving both parties. In the bottom section, termed the election part, the buyer or seller marks the relevant boxes to indicate the type of agency they wish to elect, allowing the agent to proceed accordingly. It is advisable for clients to sign this form during the initial discussion of agency matters, which ideally occurs early in the READ, Real Estate Agency Disclosure and Election, form agent-client relationship. Notably, the READ form is versatile, applicable to both sales and rentals. For rental scenarios, it's important to understand that seller refers to the landlord, while buyer pertains to the tenant. Although some sites that you may use to fill in your forms, such as Zip Forms, display separate READ forms for sellers and buyers, it's crucial to recognize that they are identical forms. It is just that they fill in automatically, so make sure to use the correct one. The inclusion of sections for both by limited dual consent form. This form is essential for reaffirming dual agency in scenarios where a sale results in a dual agency, such as when an agent sells their own listing or a listing within their firm. An agent selling their own property is never to represent the buyer in the sale. Both the buyer and seller should sign this form prior to the contract being written. Although it is common practice for the seller to sign the form at the listing stage and the buyer at the time of signing the READ form, this approach doesn't effectively fulfill the form's intended purpose unless you are in a dual agency situation. As long as it precedes the offer, you should be good. When either the buyer or seller signs the READ form upon becoming a client, it merely discloses the potential for dual agency, allowing the client to choose and grant permission for you or your company to become a dual agent if the situation arises. However, the limited dual consent form is specifically designed to confirm that dual agency has occurred, and this can only be validated when the contract is being written. While it's not incorrect to have clients sign it upon becoming clients, the form serves its intended purpose more effectively when signed at the time of contract creation. Buyers and sellers sign on the bottom part to ensure that the form is suitable for use in either context after you educate them on what it is explaining. There is a buyer election box and a seller election box. Line 60 will acknowledge which one they are to the agent. The highlighted areas are how you would fill out the READ for if you are working with a seller. If you are working with an unrepresented buyer, the highlighted areas are how you would fill the READ form out. Disregard the checked boxes on lines 48 and 50. If you are working with an unrepresented seller, the highlighted areas are how it should be filled out. Disregard the checked boxes on lines 48 and 50. The correct way to fill out the READ when working with a buyer. Lines 46, 52 are the section for the buyer election and should match the box for the buyer on line 60. Lines 53, 59 are the section for the seller election and should match the box on line 60 for the seller. Limited dual consent form. This form is essential for reaffirming dual agency in scenarios where a sale results in a dual agency, such as when an agent sells their own listing or a listing within their firm or brokerage. Both the buyer and seller must sign this form when the contract is initially written. Although it is common practice for the seller to sign the form at the listing stage and the buyer at the time of signing the READ form, this approach doesn't effectively fulfill the form's intended purpose. When either the buyer or seller signs the READ form upon becoming a client, it merely discloses the potential for dual agency, allowing the client to choose and grant permission for you or your company to become a dual agent if the situation arises. However, the limited dual consent form is specifically designed to confirm that dual agency has occurred, and this can only be validated when the contract is being written. While it's not incorrect to have clients sign it upon becoming clients, The form serves its intended purpose more effectively when signed at the time of contract creation. If you are the listing agent and now have a buyer who wants you to represent them, this form is filled out before writing the offer. Both parties must agree to dual agency. In some instances, buyers and/or sellers do not want the same agent representing both sides. The buyers and sellers' names go on lines 1 and 2, the property address on line 3, and the brokerage on line 4. You as a professional agent should go over the differences that are caused by dual agency. See lines 14-25. An example would be if the seller asks you what the buyer's top price would be. Unless you have written approval to discuss this matter, you can't. Exclusive Buyer-Broker Employment Agreement. This agreement is designed to establish an exclusive relationship with a buyer before presenting any properties. It establishes a binding, two-way exclusive arrangement and may involve the buyer paying a retainer fee and/or commission. Ask your broker if a retainer fee is allowed. It should be executed during the initial discussion of agency with a buyer, and its use requires the explicit knowledge and approval of your broker. The adoption of the Buyer-Broker Exclusive Employment Agreement, BBEA, in Arizona was not widespread. Now that the seller is not obligated to pay a buyer's agent a commission, it is required to have this form agreed upon prior to showing any homes. Real-life story. A buyer's agent discussed this form with their client and filled it out, and it was fully executed. The agent put in a specific city. Yep, you guessed it. The buyer bought another property in another city and claimed he did not have to pay the original buyer agent due to the fact that the form said the agent would show homes in a certain city. The original agent took the buyer to court, and the end of the story is that the agent had to pay $75,000 in attorney fees, file for bankruptcy, and almost lost their minds from the time and energy spent on trying to win their case. In order to pay for the attorney, the agent also had to sell most of their assets. The commission that the agent was fighting for after months of showings and educating this buyer was $18,000. Worth it? I would say not. This form will also dictate to the buyer what the agent will receive in commissions. Lines 33-36 draw out how much the buyer's agent will receive. Remember that the listings are no longer offering a co-broke to buyer's agents in MLS. This is done between the buyer and the seller through a signed seller compensation addendum, buyer agency and seller waiver and confirmation disclosure form. This form is intended for situations where a listing from another firm is being sold, and the listing agent has directed the presenting of the offer directly to the seller. Although not a widespread practice, some limited service brokers engage in this form of real estate sales. These brokers may exclusively list the property, place it on the MLS, and even install a lockbox. However, their involvement often ends there, and they do not participate in the contract presentation and negotiation. The selling agent should complete this form and present it to the seller before submitting the offer, obtaining the seller's signature. The form serves to waive the seller's right to have their agent present and clearly communicates that the selling agent represents only the buyer, not the seller. The selling agent is the buyer's agent. The leasing agent is the marketing and negotiating agent for the seller. When encountering a notice in the MLS indicating the need for this form, be aware that the listing agent, while representing the seller, may have minimal involvement in the transaction. This situation can place the selling agent in a challenging position as they represent the buyer, and their fiduciary duty is to the buyer. However, fairness and honesty must be maintained with all parties involved, including the seller. This delicate balance may require careful consideration when responding to questions from the seller. The selling agent must navigate providing assistance while avoiding any compromise to their fiduciary obligation to the buyer. All the aforementioned forms are readily accessible to all member brokers, and their usage is optional. Although brokers can choose the forms they use, AAR simplifies the process by providing these forms as a standard in our state, making the selection and implementation of forms more convenient for brokers.